Warhead, you'll begin. You have 15 minutes. You can save up to 5 minutes for rebuttal. When you take the podium, just let me know how much time, and I will do my very best to try to monitor that for you. Assuming that clock continues to work, you can also keep an eye on that, but keep in mind your rebuttal time will be taken from the full 15 minutes. We are ready to proceed when you are.
Thank you, Your Honor. May it please the court, I'm David Warhatch, and I represent the intervening appellees in the case. That's Victoria Shepard, who's in the courtroom with me, as well as Corinna Guevara, who are the co-owners of the property that's next to the appellee's parcel that's at issue in this zoning matter. I'd like to reserve 5 minutes for rebuttal time. I remember whenever I was a federal judge's law clerk, one time there was a challenge to an arbitration award, and in a union contract setting, and the union won the case, and the judge, we were presented with the possibility of vacating that order. And the judge asked me what I thought. I told him I thought that the arbitrator had exceeded his powers, but the judge ultimately said, no, I was the president's appointee, we're going to go and we're going to go the other way. A few months later, after I left the court's employ, I got a note from the judge with a slip opinion from the Sixth Circuit. And he said, I thought you'd be interested in, I wrote the opinion, and the court called it a heroic effort to try to save the arbitration award, but ultimately said it did not satisfy the law. I think that what the judge did in this case was a heroic effort to try to help Magnolia, but ultimately she did not follow the law correctly. And that's why I'm asking the court today to recognize that and make amends. The roadmap for this case is as follows. The decision tree first is whether or not the ordinance at issue, section 120302G4 of the Land Development Code of the City of Hudson, Ohio, was ambiguous. If it was not ambiguous, then the law is very clear. You apply the law as it is written, because the court is not to be a super legislator to correct deficiencies or defects or gaps that might be in the law, but rather to look at the law and its intended purpose and to interpret it and the words used by the legislative authority in the way in which that legislative authority intended in carrying out that purpose. If the court, on the other hand, finds it to be ambiguous, then there are a series of rules of statutory construction that can be applied. In this case, it's clear from the opinion of Judge O'Brien that she found that the ordinance was unambiguous, and then went ahead and applied principles of statutory construction to try to come up with the interpretation. Well, the cases are very, very clear. The court is to interpret what was enacted by City Council and give ordinary meaning to the words that City Council used, assuming that City Council did not include any words to be redundant. You're supposed to interpret those terms in context with one another. And you are to, in cases where there's an exemption that is claimed, you're to give strict construction to the words. So here's the issue in this case. The judge finds that it is unambiguous, and then tries to associate the first sentence of the ordinance with the second. The first sentence of the ordinance says, if you get a zoning certificate from Hudson, you have to commence construction within 6 months and complete construction within 2 years. That's all it really says. The reasons why that's in there are in the record. The second sentence then says, there could be exigent circumstances where you need an extension. We'll consider the extension. And in order for you to get the extension, the only condition you have to meet is to show that you have worked continuously on the site for 24 months. Well, the problem is that the judge has basically said that you must have worked the area of the project for 12 months already before making the application. But the ordinance doesn't say that.
Well, the ordinance also doesn't say to apply, you need to apply 30 days before the permit, or not the permit, but the certificate expires.
That's right, Judge. It doesn't say when you have to apply, but that doesn't.
Well, it does, doesn't it? It says 24 months.
No, ma'am. It says.
Well, that's your interpretation.
No, you can't distinguish. You can't say that the first issue about whether or not the zoning certificate is still valid is how you determine when you can apply. That's not at all the law.
Well, and you see, and the only reason I say that's your interpretation is because it seems like you're not just following the plain meaning, just like maybe the judge isn't or like the other side isn't, because we're all putting things together to determine the meaning. So it sounds like everybody's arguing it's ambiguous, but still says it's not ambiguous.
Well, the judge found it not to be ambiguous.
Well, then she also said if it is ambiguous, blah, blah, blah.
Right, we'll get into that in a moment. But it says, these time limits may be extended by the city upon a showing that there has been continuous construction activity on the site during the 24 months of the date of issuance. That does not say that they couldn't, on the day after they got their certificate, say, oh, we're going to experience a 1-year delay in receiving materials, so therefore we need an extension of the zoning certificate. They could have done that.
They just couldn't have gotten it.
Pardon me?
They just couldn't have gotten it.
No, if they had established for to the satisfaction of the director, that they worked the site otherwise during that first 24 months but couldn't get it completed, then they would get their extension. It's the difference.
But I thought you said the day after.
They could, the day after, but the zoning inspector, the director of community development, would then hold that application in abeyance to see that they are working the site otherwise.
That's why I said they couldn't get it completed, that's what I meant.
But at the end of the 24-month period, no matter when they applied, then the director would be called upon to say, okay, but for this problem of getting materials, did they work the site? You can't just simply work the site for a year, take a year off, claim that you couldn't do it for whatever reason, and then try to come back another year later, effectively defeating the first part of the ordinance.
But that's not what happened here.
No,
Right.
but they could have applied before the zoning certificate ended. They didn't, they waited till 89 days after the zoning certificate expired to make an application, and then only after they got a stop work order. To my mind, they had plenty of opportunity, especially as early as April of 2016, the record makes it clear that they claim, there's evidence in the record suggesting that they claimed that they couldn't get certain materials. And therefore there was a delay, maybe up to 6 months. But if they had that happen, they could have applied immediately. The zoning director, the planning director would have just held on to the application, see that they were continuing to work the site. There were other things they could have done, including laying the foundation and starting construction of the garage that was there as well. It's part of the same project, one phase. They didn't do that either. And in the record, there's clear evidence that that constitutes failure to commence construction within 6 months. That's an issue the Board of Zoning Appeals and Building Appeals did not address, but that's in the record as well. On remand, that will be raised.
I'm curious, I don't mean to put you on the spot, but that's what we do when the attorneys come in to argue, we put you on the spot.
That's why we're here.
Okay. How would that work if you have to prove you have had 24 months of continuous work, okay? And the certificate becomes automatically null and void. I mean, it's at the same time, how do you do that?
Well, the judge thinks there's an impossibility of enforcement, but we disagree.
Well, I just want you
Because it says, has there been continuing construction activity on the site? That doesn't mean that you have completed your work or that you've worked all 24 months. The question is, have you continued your activity? They could have, instead of working on the house, they could have gone to the garage. They could have built the other improvements on the property. Instead,
Well, they could have landscaped it ahead of time too, but maybe in practical application, that wouldn't have worked.
correct, and that would be one of the reasons why they would say they needed an extension, because they can't do the rest of the work until these other projects are done.
But I'm still confused because I don't understand, how do you approve the extension without showing the 24 months of continuous work? That's what I'm getting at.
Well, that is the standard. Continuing construction activity is the standard. That means, did you deliver materials to the site? Did you work on other aspects?
That's not what I'm talking about, I'm sorry. I'm talking about the actual time period.
And
Let's assume they did 24 months of
Yes.
continuous
construction.
activity. The moment the 24 months is up, after you get the certificate, according to your argument, I understand it, it's null and void.
No. The certificate at the time of application for the extension has to be valid. If it was still in effect on the date they filed, if they filed on the day before the second anniversary, a request for an extension, it's a valid request that would have to be reviewed by the director. In this case, they deprived the director of any discretion whatsoever, because they came 89 days after the zoning certificate already had expired. So,
Council, the other side of that coin, and they deprived the director, but Hudson didn't exactly wait till one day past 2 years and say, well, too bad, you're now null and void. Hudson also waited 89 days before they issued a stop work order.
no, they waited 82 days.
All right, 82 days, I stand corrected.
But you know, of course, the cities are entitled to broad discretion with respect to enforcement issues like that. They could have looked at it and said, well, if you make an application 3 days, 10 days, we're not going to worry about it. But this was 89 days after the fact. And I don't know what the record is going to ultimately reflect in this case, based on what I see being laid out in front of us here in terms of diagrams. But at that time, it was clear there was plenty to do.
You're a little under 5, I'm sorry.
I'm sorry, oh, thank you. There was plenty yet to do. And they hadn't even started construction on the garage part of the project until a day after the zoning certificate expired. Under the law, you commence construction under Ohio law, under Hudson law, by putting the in-ground foundation in. They didn't do that till the day after the second anniversary of the certificate. So therefore, they were out of line altogether. And the city, I think, exercised the proper discretion in getting a stop work order issued at that point.
So this has been sitting there with nothing being done on it for the past how many months?
No, I didn't say there was nothing being done. Toward the end, there was things being done.
I mean,
But
since the time
there
it was
were-
null and void.
they claim there was a 6-month hiatus or so because of lack of materials, and they claim a 3-month or so hiatus because of the principal owner's rotator cuff surgery. But never did they go to the zoning director and say, we need an extension because of those things.
I guess what I'm asking is, since the stop work order was issued, there's been nothing done on the construction.
There was a little bit of work done to try to avoid some ill effects of weathering, which we did not oppose. But that was done with the court granting leave for them to do that. But otherwise, since then, as far as we know, is that right, Dory? There's been no work done on the property since that point in time.
I stopped the clock for you because of the
Thank
Shane's
you.
question, but
Thank
no,
you.
you don't need to apologize. I've been even on the other side also.
Good morning. May it please the court. My name is Steve Bond. I'm here with my colleagues Dan Wright and Chris Teodosio on behalf of Magnolia Investments, LLC, the owner of our property, and the principals of the property are here this morning too. You know, you have to at least love the ingenuity of Lorraine Porter. That's the lady who owned a 2-story house out in the city of Greene. She observed that her house windows looked out on the driveway of her neighbor's house. She was concerned that her neighbors were going to be looking in those windows and seeing her walking around in her pajamas. That was her testimony. She knew that she could build up to a 6-foot fence, but she also knew that because of the incline of her property and the neighboring property, 6 foot wasn't going to do it. How to solve the problem? She built a 3-foot mound along the boundary and then put the fence on top of that. From the top of the mound to the top of the fence was 6 feet. The city and the neighbors were outraged. And when this case finally came to this court, in Porter versus Greene Board of Zoning Appeals, this court held. The ordinance says you can have a 6-foot ordinance. It doesn't say how you measure it, or that there's any special way of measuring it. When the language of the ordinance is clear, you apply the words as written. And this court also held that it's not a question of what the city may say was intended or the way that it could have been written. The issue is how was it written, and that's what this court said to enforce. I ask you to keep that decision in mind when you think about the facts of what happened in this case. Magnolia was working on a continuing basis to construct and remodel this house and garage. City comes out, issues a stop work order. Mr. Hannon, the person in charge of enforcing the rules, calls up Mr. Fritz, according to Mr. Fritz's testimony, and says what you have to do is apply for an extension of your zoning certificate. When Mr. Hannon was testifying at the Board of Zoning Appeals, he conceded, yes, I remember, I called him and I did tell him to request an extension of the zoning certificate. So, Mr. Fritz sends in a letter on January 11th saying, based on our phone conversation, we are requesting a continuation of the zoning certificate. Mr. Hannon writes back, we got your request. At this time, the stop work order notice will remain in place while we investigate the work completed to date to confirm its compliance with the applicable standards of the Land Development Code. Now, he didn't write back and say, why are you doing this? This is baloney. You can't ask for a continuance. He created every impression like, yeah, that's the legitimate way that you should proceed at this time. What does the city do next? Catch-22. They write back and they say, aha, that's that letter down on the bottom there. Aha, I may have told you that you could ask for an extension and you may have done exactly what I told you, but you can't get an extension. He doesn't explain on what basis he suddenly changed his view of what the ordinance said. The whole issue arises from the language of that specific ordinance where it says these time limits may be extended by the city. It doesn't limit the time when it can be extended. It doesn't prescribe a window, like you have to come in during the last day, 30 days, or you have to come in before it's expired. And it uses that language about the 24 months, which creates a scenario that if you are coming in after 24 or before 24 months, how can you explain what has happened during the whole 24 months? Or at the very least, if you're coming in on the day after the 24 months, everything you've done up until that 24 months should be part of what the decision is based on. And if that's the case, then even though the time has passed, you still must be eligible to get an extension.
Counsel, your client obviously knew that when they got the certificate that it was good for 2 years, right?
Right, he said he knew that. But when the person who enforces it tells you this is what you do, and it sounded like everybody at the city was on board, that's what he did.
But that was already almost 3 months after the fact.
Well, I think as somebody commented, you have for 80-some days, the city was letting everything go. And in fact, while all this stuff was going on, there were city inspectors coming on site doing different jobs. In fact, when you talk about the garage issue, there was a city inspector out there the day before the 2 years was up who approved the footers for the garage. So the city was fully aware of this. Nobody from the city is saying up until that time, oh, you've got a problem here. You don't even realize that there's an issue.
Now, I may not agree with this line of cases, but there's a line of cases that say you don't get promissory estoppel with the city.
It's not a question of estoppel. It's a question of enforcing the exact language that they're using.
I understand, but you were talking about how everybody.
I'm only using that to say that what the city even thought was the intent of this wording is consistent with our view. Because they told him that's what you do. And when he did it, they said, okay, we're going to act on it. Only later on when somebody talked to somebody and decided, oh no, we're going to change the whole system. And the testimony of Mr. Hannon was, this had never come up before. Mr. Hannon testified at the board that this was his interpretation, not that it actually was what it said. The Board of Appeals, in their decision, said it can reasonably be inferred. When you're inferring, then you're doing something that's not what it really says. You're adding your own connotation to what happens. Judge O'Brien correctly decided that the ordinance is clear and an extension may be granted according to the exact wording of it, and she applied the words that are actually in the ordinance. To get where the interveners want to go, you have to add words, something like an extension may only be granted if it is applied for prior to the expiration of the zoning certificate. Words that are not there. Words that the city since then has added to their ordinance. We filed a notice of additional authority, which is the ordinance that the city has recently enacted. Whether it's enacted or it's just proposed is really immaterial. The point is the city knows how to write it if they want to. And they could have.
Counsel, I'm sorry, I'm trying not to interrupt you, and I don't want to step on Judge Callahan's toes, but I would just say this. We can only consider what's in the record.
I'm sorry?
We can only consider what's in the record.
Right.
So things that happen after the fact, we're not supposed to consider. Unless we're talking about a mootness issue.
Well, I think you consider issues that are a matter of public record. But again, for this purpose, it's merely illustrative of what I've been saying from the Porter decision. You can't add in words just because you'd like it to say that. Just because they could have written it that way if they wanted to. But even if you take the position that it is subject to some kind of debate, the overwhelmingly compelling rule that applies in this scenario is that when we are talking about zoning cases, because we're talking, I think of it in terms of a man's home as his castle. He can do what he wants in his castle unless there's a legitimate reason that the government imposes against it. And the rule, which was cited by Judge O'Brien, is in interpreting a zoning ordinance, a court must strictly construe restrictions on the use of real property in favor of the property owner. This is because zoning resolutions are in derogation of the common law and deprive a property owner of certain uses of his lands to which he would otherwise be lawfully entitled. So if there is a way of interpreting this ordinance so as to allow for the extension, the zoning interpretation rule is the one that would apply. We know that it can be interpreted in a way that allows it to have been extended. The interveners in their brief have tried to emphasize the fact that the use of the words null and void was part of the definition here. We've cited to authorities that talk about the fact that there are many examples of legislation where the words null and void are used, and yet after the fact an extension had properly been allowed by court after court. The interveners also talk about the idea that there's some kind of a difference between words extend or renew. Here it shouldn't have been extended, we should have said we wanted it renewed. Yet the case that they're relying on for that principle, the Preston versus Ferguson, is discussed by the Sixth Circuit Court of Appeals in the East End case, which we cited. And there the court said, indeed in Ohio, when a party exercises an option to extend, it simply lengthens the existing agreement for a new period of time. Accordingly, and contrary to the Easton's argument, when Chesapeake exercised its option to extend, it bound the Eastons to the same agreement to which they were previously bound, but for a new period of years. In other words, the same one is invigorated, but to last a longer time.
Of course, the argument there could be the whole point was existing. And they're arguing that the moment the 2 years went by without an extension being requested, there was no certificate, or as you would say in that case, or a contract to extend.
Right, but the cases that we cited in our brief deal with the idea that even though you call it null and void, does not mean that it cannot be extended after the fact. The city, in our view, was quite correct in deciding not to appeal Judge O'Brien's decision. As the ordinance was written, the city did have the authority to extend it. There was a way that it could have been written, and they chose not to do that. Since the new ordinance hasn't taken effect, it, of course, is completely irrelevant to this issue. Judge O'Brien was correct, and we ask that her decision on this point should be affirmed by this court. Thank you.
Thank you, Your Honor. With respect to the extend versus renew issue, I think Judge Carr, you nailed that one on the head, because that is amply covered in the brief, and it's very clear that notwithstanding what the Sixth Circuit said, what we're dealing with here is a zoning certificate that by its very nature, de jure, became null and void as a matter of law. The issue about time limits is kind of curious. Theoretically, the request for an extension could also apply to the extension to commence construction as well. All they're referring to is the 2 time limits that we're talking about in the zoning certificate. which are mentioned right in the zoning certificate itself. So the owner is on notice upon receiving the certificate that you need to do these things. The issue with respect to the time limits is merely what we discussed before, and it's amply described in the briefs, in the reply brief in particular, pages 6 and 7. Learned counsel opposite on the question of the inferences, I think has misstated the law unintentionally. If there are inferences allowed, the inferences are allowed to the extent of sustaining the purpose of the legislation, not destroying it. This is at page 13 of our merit brief. What learned counsel opposite tries to do is to frustrate the purpose of this ordinance. It very clearly, the purpose of it is we don't want zoning certificates laying around the city where work is not being done. We want either you get the work done within 2 years, or come to us and explain to us why, so we can determine whether you are entitled to an extension. That's the purpose of the first sentence of the ordinance. You can't read the second sentence and the words "these time limits" or time limits in a way that frustrates the first sentence part. And to the extent Mr. Hannon, in fact, was saying this was his interpretation, A, that's his job. And B, his interpretation is subject to the review of the Board of Zoning and Building Appeals, and their job is to determine whether he made the right interpretation. And though all of those folks, all 6 of them, said that this is the correct interpretation, and to the extent that there's any inference that was drawn by Mr. Hannon in making that interpretation, he did that consistent with the principles of law cited at page 13 of our merit brief, which say that all such inferences are allowed only to the extent of sustaining the purpose of the legislation, which clearly is expressed in the first sentence: we don't want stale zoning certificates.
But the way I'm reading that second sentence, and correct me if I'm wrong, because this is how I'm seeing you're reading it. These time limits may be extended by the city upon a showing that there has been continuing construction activity on the site during the 24 months of the date of issuance, and the builder applies for an extenuation before the 24 months is up. Is that your contention, that they need to apply before the 24 months
They
is
do
up?
have to apply because
Okay.
they can't extend a null and void certificate. That's what that extend versus renew is all about. What Judge Carr was talking about is exactly it. If the city had said renew by showing 24 months, different story. They said extend. You can't extend an instrument that doesn't exist anymore. And whether you want to say it's a legal fiction that they're engaging in, but the law is very clear. It lapses and is null and void on the 2nd anniversary. If you haven't completed construction by then, you don't have a valid certificate. The fact that other steps have been taken afterwards, there's a motion to strike the supplemental authority.
We're aware.
Okay, thank you. None of that has taken effect yet, and frankly, I don't see how a city council trying to tell a court we really meant what we said at the Board of Zoning and Building Appeals is an improper use of the city's legislative authority. It looks like my time is up. I ask the court reverse and order the court to enter judgment sustaining the Board of Zoning and Building Appeals decision.
All right, thank you. We'll take this matter under advisement, issue our written decision in due course, make sure it gets mailed to all sides.